Good afternoon, everyone. It's nice to be here talking about a topic that has been raised in so many new contexts during the last many months of the public health emergency. So as testing and vaccine, as those processes continue, one question that we are frequently asked is how HIPAA applies in the context of sample collection, testing, reporting, vaccinations, and just and many of those related contexts. So as many of you know, HIPAA refers to the Health Insurance Portability and Accountability Act. It's been in place with us since 1996 and has been updated over the years to provide for various protections. Healthcare providers, insurers, and to some extent employers have been navigating HIPAA for years. But with the new way of life that we find ourselves in, obviously new questions are arising. And they're often, typically we've dealt with HIPAA so frequently in the healthcare context, and now we're seeing some recurring questions, as Pete said, arise on kind of a daily basis outside of that typical setting. So I wanted to address just a couple of general background questions that we've been asked over the past few months, and try to narrow down some of the main focus of when HIPAA applies and why, and when it may be a consideration for you. So the first question I've posed here is HIPAA being enforced during the public health emergency? That's frequently being asked, and the answer is absolutely yes, it is. You may hear comments that the Office for Civil Rights, or OCR, they're the office that has been charged with enforcing HIPAA. You may have heard comments that they've decided to exercise discretion in enforcing certain provisions, and that is true. However, it doesn't mean that HIPAA is not being enforced. Although much of the information can be shared on the basis of the existence of the public health emergency, or the fact that disclosures are made to public health authorities as opposed to other entities, OCR is still very much enforcing, through penalties, HIPAA violations. Additionally, the initial focus of the enforcement discretion really was geared towards applications of telehealth. The OCR had explained that covered healthcare providers would not be subject to penalties for violations of HIPAA when they occurred in the good faith provision of telehealth during the COVID-19 public health emergency. So there is that sort of blanket enforcement discretion going on. In fact, just last week, they've sort of updated that to apply to certain web-based scheduling applications that are used for reporting and vaccination scheduling. But generally, HIPAA is still in place and it is still being enforced. So now that we understand that HIPAA is still a concern, the next big question is, does HIPAA apply to me and or my organization? And I think it's important to keep in mind that the definition and the scope of HIPAA hasn't really changed during the pandemic. So HIPAA still applies only to covered entities and business associates. By way of a brief background, I guess I should note that a covered entity typically includes healthcare providers if they transmit certain information electronically. And remember that when we're talking about HIPAA, we're only dealing with protected health information. And typically that is information that's being transmitted electronically for certain purposes. So a covered entity is usually a healthcare provider, health plan, or a healthcare clearinghouse. And a business associate under HIPAA is an entity that is engaged by such a covered entity to assist in carrying out certain healthcare functions or activities, where there is also an exchange of, again, protected health information. That's key. That needs to be part of it. So a full analysis as to whether your organization or which parts of your organization need to be concerned about HIPAA does in fact depend on what services you're providing, what business you are operating, etc. But in short, HIPAA should only apply to you and or your organization to the same extent as it did before the pandemic. It may be that the only individuals in your organization, for example, that are concerned with HIPAA are HR professionals that are interacting with with your organization's health plan. That may be the limit to it. For others that are providing more extensive healthcare or related services, then that's obviously going to be a bigger concern. But the fact that your organization has or receives health information or medical information does not, in and of itself, make you a covered entity or a business associate. And that really is where a lot of our questions have come from, is that sort of concern of, we have this information that's being provided to us, or we're being asked to provide this information that we've received. And to the extent that you have that, it doesn't necessarily make you covered by HIPAA. Now, it may be, and this is, again, very important to know, that information is covered by other state or federal laws. I want to make that clear, that just because HIPAA doesn't apply or is limited in its application, it doesn't mean that your organization won't have other duties or obligations to protect health or medical information. For instance, the requirements of the ADA and FMLA still apply to that information. So I think with that in mind, the last question I want to discuss, and this is a bit of a newer one. It's really arisen in just the last couple of months of the public health emergency, as we're really sort of stepping up the vaccination process and the reporting process to a greater degree. This question is, do I need a business associate agreement to provide information about those involved with my organization? For example, do I need a business associate agreement to provide information about students, employees, or others to a lab for purposes of testing? Unfortunately, this answer isn't completely definite, or maybe I should say it's not definitively answered just based on that question. It is a very fact-based question, but the answer to that is maybe not. You may not need a business associate agreement, and I'll describe a little bit about, for those of you who may not be familiar with what a business associate agreement is. It's frequently called a BAA, and it's an agreement that is entered into by the covered entity. Remember, that's usually the healthcare facility or health plan, and their business associate who's providing those supporting services to the covered entity. So a business associate agreement is required in situations where there's an exchange of protected health information of individuals between the covered entity and the business associate. We have seen this issue arise frequently from this question has arisen frequently from entities that are not typically in healthcare, but who are required to conduct testing. This would include schools and general businesses that are required to conduct that testing. And in recent months, we've had a number of testing companies, labs, and even local health departments try to force organizations to sign business associate agreements in order to share information. And I'm not saying, I know I use the word force and it has kind of that negative connotation to it. I'm not saying that a business associate agreement isn't always appropriate or necessary, but I think there needs to be an analysis done by you and your organization prior to just sort of blanket signing that document. It's important to fully realize whether you are truly covered by HIPAA, and certainly OCR, again, the agency that's been charged with enforcing the HIPAA regulations. It's key to them. One of the big concerns to them is, does an organization understand its role under HIPAA? And if you're signing a business associate agreement when you're not truly a business associate rather, there I think are some red flags and some concerns. So my comment and my advice, I guess, is that just please keep in mind that the fact that your organization receives health information or medical records does not necessarily by itself make you covered by HIPAA. And there still may be times when you need to enter into a business associate agreement, but be sure to coordinate with legal counsel as appropriate to